Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me again in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hi, Ariana. Thanks for having me back.
Thank you so much for being here. For today's topic, we will be answering all your pressing questions on travel for F-1 students. Before we begin, I'd like to remind you that this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you have questions, please comment them below or email us at info@chuk.com so we can help you out. Now, Min, I know we have a lot to cover as usual, so if you don't mind, we can just get right into it. With the summer months on the horizon and folks looking to travel internationally, there are some special considerations that foreign nationals should keep in mind before they hop on their international flights. Am I right in assuming this?
Yeah, you're absolutely correct. One of the most essential and prominent actions that a foreign national here in the U.S. in a visa status can do is to decide to step out and travel abroad. Whether it be a quick road trip across the border to Canada or Mexico, or let's say hopping on a flight back home. Traveling internationally can bring forth a wide range of visa status issues that the traveler must be aware of before choosing to depart. And some of these important factors are not even based on the law, but are sort of entirely procedural or administrative issues such as delays at the consulate in securing a visa appointment or the timing and context of when the foreign national actually steps out of the U.S.
Well, I assume that such things like consular delays and securing an appointment are not within the control of the foreign national. But why would the timing of when the foreign national steps out have much impact on whether she, for example, the student, can return?
Yeah, it's a good question. But just take the example of that F1 student, as you mentioned. Some things to consider for that student are whether she can or whether she has completed her degree program, or is there still an academic curriculum awaiting to be completed by her when she returns back to the U.S. Other things to consider is the F1 student work authorized pursuant to an approved EAD card? And is she returning to her EAD employer? Or maybe she has an underlying STEM degree and has since applied for an extension of the EAD. Has that 24-month extension since been approved? And is the EAD in hand? Or is she perhaps still waiting for the EAD to be fully adjudicated? Or maybe the F1 student is the beneficiary of an H-1B cap petition. Has that petition been finalized and filed? Is it pending still at USCIS? Or has it been approved? Was it filed to request constant notification, or perhaps a change of status to take effect on October 1st?
Wow. Okay, Min, I get it. Point taken that the timing of all these variables certainly appears to matter and perhaps also steer the strategy a foreign national should consider before deciding to leave the United States for the summer months. But since you bring up the topic of F-1 students, maybe we can start there because I know that since we are still in the midst of the H-1B cap season while simultaneously having many F-1 students be on summer break, international travel for such students is a topic worth exploring.
Yeah, absolutely. I agree with you there. Kind of, diving into this topic though, because it is so fact specific and fact dependent, perhaps it's best if we go over, I believe, some hypothetical situations together. So if there's a certain fact pattern which aligns to what one of the audience members in attendance might find himself or herself in, then they perhaps would know how to proceed in scheduling, their specific summer travel plans.
That sounds like a great idea to me. Let's get started on that.
Okay, so I suppose the first hypo that comes to mind is, starting with an F1 student, who is currently working on his or her initial 12-month period of post-completion OPT. For students who find themselves in such situations and who are not beneficiaries of an H-1B cap petition to change their status to an H-1B worker because let's say their individual H-1B cap registrations were not selected in this year's lottery, so long as they are in possession of their EAD card and the EAD remains unexpired, such F-1 students should be able to depart the US and return back in F-1 OPT status in order to resume their qualifying OPT employment. And also to help with that return travel and admission back to the US, I would advise those F-1 students to have a confirming letter of sorts from their OPT employer, verifying the employment the F-1 OPT student will be in fact returning to.
Okay, that sounds simple enough. Now, what's next?
Well, I guess it gets a little bit more complicated beyond that basic scenario. If let's say if the F-1 student's post-completion OPT has yet to be approved, in the earlier hypo, we assume that the F-1 student already has his or her 12-month EAD card, which remains unexpired and which can show the CBP officer at the port of entry along with the verifying employer letter. But let's say if the F-1 student finds herself in a situation of having completed her academic studies, but still waiting for that post-completion 12-month OPT EAD card, I believe she's going to have some issues in looking to come back to the US. I personally, if I were counseling such an F-1 student, I personally would not advise for that student whose post-completion OPT remains pending to travel overseas.
Wow, that's quite the change. But I can see now what you mean when you said earlier that the timing for the foreign national and the underlying context oftentimes drives these decisions to leave the US. So, what about STEM OPT extension? If the F-1 student is waiting for her 24-month STEM OPT extension to be approved, does the same advice of not traveling apply here?
Well, I mean, as with most things, within immigration law, it sort of does depend. If that F-1 student who is waiting for her 24-month STEM OPT extension in your example, if she still has a valid EAD and a valid F-1 visa foil within her passport at the time she is set to return, then leaving the US and looking to come back in F-1 status shouldn't be too much of a problem, even considering that 24-month OPT EAD application, if it's still pending at USCIS. But the analysis somewhat changes when that initial 12-month grant, a post-completion EAD is expiring. For those F-1 students whose initial grant post-completion OPT has expired, and those students who are still waiting for that STEM OPT extension to be approved, international travel and returning back to the US in F-1 status should still be okay. But I would still advise for that person to have much more extensive documentation than normal, not including customary things that apply in most situations, such as a valid passport and F-1 visa foil that permits multiple entries. Such an F-1 student should also carry items like the I-20 certificate received from her DSO at her university, ensuring that the I-20 has been endorsed by the designated school official in the last 6 months of STEM OPT for work and for travel. They should also carry with them their expired EAD card, a copy of the STEM OPT extension request, and the I-797 receipt notice for the pending application. And also it'll be helpful to receive a letter from the OPT employer, once again, verifying the OPT employment the F-1 student will return to after their international trip.
Okay, so all of that sounds pretty reasonable. It seems like most of the rules are rather flexible in allowing such international travel for F-1 students. Are there circumstances when such travel is not recommended?
Well, I suppose one thing that immediately comes to mind is a situation of an F-1 student who might be in her 60-day grace period. If the F-1 student has since completed her course of study, has not filed for any post-completion OPT work authorization, nor been the beneficiary of a change of status petition, such as an H-1B cap petition filed on her behalf, then looking to step outside of the US during that grace period on the notion that there won't be any issues in quickly coming back as an F1, unfortunately, it won't work. You have to keep in mind that the F1 status is terminated. There is no academic course of study to return to in continuing F1 student status, nor is there any OPT employer to return to. And if there's no change of status that has already taken effect, like changing to an H-1B employee upon the start of the government fiscal year, then there really is no basis for the F1 student, unfortunately, to be readmitted to the US.
But wait, Min, what about those F1 students who might have finished their course of study but have chosen to not file for an OPT EAD and whose H-1B cap registrations have been selected and those H-1B cap petitions approved? What are they supposed to do? I know the government fiscal year starts October 1st every year, and most of the H-1B cap petition approval notices have a start date of October 1st. These beneficiaries are not allowed to leave the US even after their H-1B change of status petitions have been approved?
Yeah, unfortunately, that's right. It sort of all hinges on what the foreign national is returning to. As you stated, the F1 student completed her academic course of study. There are no classes to return to after she comes back from traveling overseas. She also cannot, return to her H-1B employer because H-1B employment does not commence until October 1, the start of the government fiscal year. So, as you noted, there is no OPT employment because the F1 decided not to apply for her post-completion OPT EAD. So if someone finds themselves in that situation, then they sort of have to remain outside the US and first secure their H-1B visa from the consulate and look to return closer to the October 1st H-1B start date.
Wow, that's alarming, and hopefully something our audience is well aware of, especially if they find themselves in similar circumstances. So if you are watching this and have questions about this, please reach out to us. We would love to help you out with that.
Yes, most definitely. But the result changes if the F1 student has applied for and already received his or her OPT EAD, which remains valid and unexpired. Here, there is something to return to, the OPT employer. So coming back to the US in F1 status shouldn't be an issue, provided all the requisite documents that I mentioned earlier, like the EAD card, the I-20 form, endorsed for travel, and so on, are in place.
That's all really good to know and to keep in mind. Is there anything you want to further add before we move on to the next hypo?
Just that beneficiaries of an H-1B cap petition should also be aware of the rules surrounding cap gap. Going back to your earlier example, you said that the F1 student was the beneficiary of an H-1B cap petition. She finished her course of study but chose not to apply for an OPT EAD. But something to be aware of is that even though foreign travel is not recommended, an H-1B status does not officially start until October 1st. If the H-1B cap petition was filed requesting a change of status to H-1B effective 10/1, then cap gap covers that F1 student so long as she remains in the US and provided that the H-1B cap petition was filed before the course of studies concluded. So, concerns such as being out of status by the F1 student, those concerns are avoided, which will definitely help later on when other visa petitions are filed for that same F1 student, since she will need to show that she continually maintained visa status throughout her US stay.
You mentioned cap gap. Wasn't that one of the proposed changes Homeland Security was going to make as part of this H-1B modernization rule that is being worked on?
Yeah, that's correct. That's great memory there, Arianna, for bringing that up. We touched on that, I believe, when I was here with you last.
Yes, we did. And for our audience who might have missed that live session from earlier this year, please check out our social media so that you can be brought up to speed on the latest. Okay, Min, let's switch gears here and talk in depth about beneficiaries, specifically those same F1 students who have petitioned for an H-1B cap number. But before we pivot to to this next talking point, any other tidbits that you'd like to share with our audience?
Perhaps just the fact that F1 students should be mindful of the number of days they spend outside the US while their OPT EAD remains valid. Now, this doesn't really have much to do with those F1 students being able to return to the US, as we just sort of talked about. But regardless, it impacts their ability to continually maintain their valid visa status and not violate the terms underlying the grant of their OPT EAD. If an F1 student secures an approved post-completion 12-month OPT EAD, the current F1 rules prescribe that the student cannot accumulate more than 90 days of unemployment. And if the F1 student has extended her OPT due to a qualifying STEM degree, then that marker is 150 days of unemployment. So, time spent outside the US while one's EAD is valid, when that time away is not authorized by an employer, is counted as unemployment days. Thus, if our, let's say if our F1 student who decides to go backpacking all through Europe for 3 months or return home to Asia to visit family for the summer, then those days are counted as unemployment days and brings her closer to that threshold marker of 90 and 150. So in addition to perhaps facing issues in seeking to be readmitted to the US after such lengthy international travel, there are underlying status issues that our F1 students should be mindful of, which impacts her ability to continue to reside and maybe even work in the US if she were to change to another visa status or look to file for a US permanent residency down the road.
That's a really important point, Min, and something I would hope our audience does not just gloss over. It really underscores the point that every decision a foreign national makes, whether it be work related or travel related, really impacts their future stay in the US and the visa related options that might be available for them in the long term. Okay, so now with that covered, let's talk about H-1B cap since the cap season is winding down in less than a month. Whether it be an F1 student being sponsored for H-1B cap this year or perhaps someone else in a different visa classification, what should our audience be aware of in these final days of H-1B cap season?
Okay, well, I suppose we can start with the concept of requesting a change of non-immigrant visa status and how foreign travel might affect that request. Um, you know, uh, Whether a foreign national is in F1 status or some other visa status in the US, if she is the beneficiary of an H-1B cap petition and that H-1B employer in filing the cap case requested a change of visa status to take effect on or around October 1, then traveling abroad while that H-1B cap petition remains in process at USCIS will undo and abandon the change of status request. And that aspect of the H-1B cap petition, unfortunately, will be denied.
Wow, wait a minute. So you're saying that the H-1B cap petition will be denied if our H-1 student happens to leave the US before a decision is made on the H-1B cap petition her employer filed for her? Is this across the board? What if she just wants to step out and visit nearby Toronto because her sister's there?
Well, it's not that the H-1B petition as a whole will be denied. And this is where, I suppose a distinction needs to be made on, what the H-1B cap petition includes. The petition, I suppose it's in two parts. We're requesting a change of status, but we're also requesting the visa classification for the H-1B might be approved. So, what might be approved is that visa classification, the H-1B visa classification, because one, the offered role qualifies for H-1B visa classification, and two, the beneficiary being sponsored also qualifies. But what might be denied is that second change of status request. So, without getting too deep in the weeds, in all this, in order for a foreign national to request changing his or her visa status from, let's say, F-1 or, an H-4 to now an H-1B worker effective October 1st, that beneficiary must be maintaining that F-1 or H-4 visa status throughout the adjudication of that entire H-1B cap petition. Um, the audience, I suppose, one thing to bear in mind is that one does not hold visa status if the person happens to leave the US. So if changing visa status to an H-1B worker effective 10/1 requires that the person continually remain in the US, if our F-1 student, who wants to leave to go backpacking through Europe, if she happens to depart, before a decision is made on the H-1B cap petition that was filed for her, she will either need to secure an H-1B visa close to around 10/1, the H-1B start date, in order to return to the US, or if she is not planning on staying outside the US for that long, and assuming that there is something F-1 related to return to, like going back to class or an OPT employer to return to, as we talked about earlier, she may be able to return back as an F-1 student. But even in the second scenario, the H-1B change of status that was requested earlier with the cap petition, that H-1B change of status request, that will still be undone, given that she engaged in foreign travel and stepped outside the U.S. before the change of status request was fully adjudicated. Now, if this were to kind of come to pass, and if the change of status request were to be abandoned, in the alternative, that same employer might need to file a second H-1B petition requesting to change status all over again, since the first one was abandoned due to her departure before the H-1B cap petition was approved. And it probably goes without saying then that the F-1 student's H-1B employer won't be all too pleased, given that it has to now budget for a second H-1B change of status request to be filed and to pay for that expense. And I suppose the takeaway point, as always, is to ensure that you as a foreign national beneficiary, you notify your employer or whoever is handling your immigration matters before finalizing any trip abroad.
Yes, that's really good advice, Min. It sort of goes back to the timing issues you spoke about earlier. So, where in the process is the F-1 beneficiary, and what's the context like? Does she have an H-1B cap petition filed for her? Has she applied for an OPT EAD or is awaiting a STEM extension of the OPT? The timing of all that really matters.
Yeah, I couldn't have said it better myself, Ariana. It really does. And to drive that point home even more, the timing of the H-1B cap petition requesting a change of status also matters too. What I mean by that is going back to our earlier example of the F-1 student going backpacking in Europe, that decision to travel overseas was made prior to the H-1B cap petition being approved. But what if the decision to step out of the US was made only after the H-1B cap petition and the corresponding change of status have both already been approved? Can our F-1 student who wants to see the world now pack our bags and make that long overdue trip to Europe? In that scenario, it's a little bit more nuanced, as it's more fact specific, but there is a compelling argument, in my opinion, that foreign travel should still be okay.
But Min, from what I know about H-1B cap, the change in visa status to an H-1B employee does not take effect until October 1st. So why would the fact that the H-1B cap petition was already approved and then the F-1 student deciding to travel afterwards make a difference? She isn't just in H-1B status yet, despite the approval of the cap petition.
True, you're right. She isn't. But if our F-1 student has F-1 activities to return to before October 1, a convincing argument can still be made, in my opinion, that our F-1 student is returning to her F-1 employer to finish up her STEM OPT qualifying employment, for example, or she hasn't yet finished her academic curriculum and then she's returning to finish her summer program. There's something there to return to, and granted, she stepped out of the U.S. prior to the change of status to H-1B taking effect on October 1. But since the change of status was already approved by USCIS, which is a key difference between this example and my previous one, the already approved change of status request is not interrupted, and it will still take effect on 10/1, despite her leaving the US temporarily prior to October 1st. Now, I do want to add a caveat here, and this goes to the broader point that these rules are in place, but oftentimes the decision made by the border officer at CBP at the US port of entry, those decisions might not adhere strictly to what the reasonable interpretation of these rules might be. For instance, going back to the example of the F-1 student looking to return back to the US after overseas travel and after the H-1B cap petition has already been approved, it's fair to expect that there won't be issues there, but a CBP officer at the port of entry might disagree. The officer might even conclude that as an F-1 student, you're only allowed to intend to remain in the US temporarily. But since an H-1B cap petition changing your visa status to an H-1B worker on 10/1 was already approved, that you as the F-1 student have shown that you intend to stay in the US far beyond the conclusion of your F-1 course of study. And in concluding that, that officer unfortunately might deny your return entry. Because you have to remember the F-1 visa classification requires the student to maintain a foreign residence in strong ties to the individual's home country, whereas the H-1B visa does not. Now, I think that such an interpretation of the rules by that CBP officer in denying entry, just because the H-1B was approved, is wrong and is overly narrow. But once again, it is known to happen. So international travelers should always seek the expert advice from either an immigration attorney or apprise their employers of travel plans so necessary arrangements can be made rather than just simply, packing up your bags and leaving.
Absolutely. The potential consequences involved in either not being able to return to the US or affecting one's visa status are just too severe to not tread carefully in those types of situations. But what about cap gap? Let's say we have our F1 student who wants to go to Europe, her EAD is expired, and she is reliant on cap gap to extend her F1 stay and her OPT employment through October 1st when the change of visa status takes effect. Any advice for our world traveler here?
That's a good question, and probably a scenario that I believe is relatively more common than some of the other hypos that we went over. Here, it's important to know that the rules have changed. Some time back, traveling during cap gap was not recommended. But now, as long as our F1 student, world traveler, has that right documentation on her, she should be able to return to the US to resume her qualifying cap gap employment. What's critical is that she return to the US before October 1, because obviously that's the day when the change of status request that was already approved earlier, it now takes effect. And in terms of the documents, the F1 student should carry on her. It's the typical things like passport, F1 visa foil, her I-20 endorsed by her DSO for both travel as well as cap gap extension and work authorization, a copy of the H-1B cap petition and the accompanying I-797 H-1B approval notice confirming the change of status to take effect on 10/1. I also would recommend, for the F1 student in cap gap to carry the expired EAD card. Because remember, it's cap gap, so obviously the EAD card will have expired. But hopefully enough time has passed since this rule interpretation changed that CBP officers at the border will not be confused by the expired EAD when you make your application for admission. Because once again, it's very fact specific and truly on a case-by-case basis.
I couldn't agree more. So apparently we're coming close to the end of our time, and I know we spoke extensively about travel situations for F1 students, but what about other foreign nationals and other visa classifications? Is there anything you want to touch on there?
Just really briefly, for J1 beneficiaries, those beneficiaries should know that cap gap doesn't apply. We talked about cap gap, fairly extensively here today. But cap gap is exclusively an F-1 institution. So, those J-1 beneficiaries, they should monitor their end date of those J-1 programs. Also, knowing that the grace period for J-1s is 30 days and not 60 like F-1 students. Oftentimes, even if the J-1 beneficiary is eligible to change visa status, so, in other words, the 2-year foreign residence requirement does not apply, such individuals would likely need to wait outside the US and secure a visa stamp because of, those kind of limitations. Also, for individuals who are going through the green card process, unless you're here pursuant to an H-1B, H-4, L-1, or an L-2 visa admission, you would need to wait for your advanced parole to be approved and in hand before departing the US. Otherwise, your pending adjustment of status application will be deemed abandoned. So that's really critical to know.
Most definitely. It certainly appears that depending on one's visa status in the US, all of these rules pertaining to travel have these minor distinctions here or there, and it certainly makes it interesting but can definitely get complex. And who knew that deciding to go backpacking through Europe will have such a hazardous effects on one's immigration status here in the United States? Well, anyways, that's all the time we have for today. As always, thank you so much for joining me again, Min. I really appreciate your insights.
It's my pleasure, Ariana. Thank you for inviting me.
So that is the end of our conversation. Thank you everyone for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If this video was helpful, please make sure to give it a like and share it. And if you have any questions or suggestions, please email us anytime at info@chuk.com. Let us know what topic you want to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you again, everyone, for joining us. A special thank you to Min and the team. Thank you so much.